Good morning. I'm the court reporter today, Susan Greenhouse. I was wondering if anyone is interested in takedown.
Zach Wilson with Debro versus Lionstone.
Okay, so you're representing Lionstone, is
Yes,
that right?
ma'am. Yep.
Okay, all right. And so you would like takedown today?
Yes, please.
Okay, thank you. If you could please just put your email and phone number in the chat.
Sure.
That would be great. Thank you.
Keith Evra on behalf of Colleen Chrisman. We would like takedown as well.
Okay, and I'm sorry, say the last name of your defendant again, please.
Sure, Colleen Chrisman.
Okay, thank you.
Yes, ma'am.
And if you wouldn't mind just putting your email and phone number in chat, that'd be great. Thank you. Okay, perfect.
Good morning, everyone.
Morning, Your Honor.
Morning.
All right, we are here on our civil motions calendar. I'm going to take them in order. Let's see who's ready to go. The first case is Debro Overstreet versus Limestone Partners LLC et al.
Zach Wilson here on behalf of Lionstone.
All right, do we have anyone here for plaintiff? All right, I'm going to move them to the back of the calendar. Maybe we can have some technical issues. Let's go to Chrisman versus Dillard.
Good morning, Your Honor. Keith Evra here on behalf of the plaintiff, Colleen Chrisman, and we're ready.
Good morning, Your Honor. I'm just fixing my video here real quick. Okay, it's not working. There we go. See me? Okay.
All right, we've got
Kevin Doyle on behalf of the defendants in this case, Your Honor, Alan Dillard and American Zurich, and we're ready to go.
Your Honor, this is Kristen Guidry, also here for the defendant. I will just be observing. So once we get started, my camera and sound will be off.
All right, thank you, Ms. Guidry. All right, let's take what I think is the easy one first. Do we have someone representing Mr. Flitt here today? Law Office of Neil Flitt. All right, so I have a motion to extinguish the purported attorney's lien of Neil Flitt. That motion is granted, and I'm signing that order.
Thank you, Your Honor.
And I will say, we gave Mr. Flitt and his office an opportunity to appear here today, but as represented in the motion and the supporting documents, the conduct here is egregious. And certainly the ultimate outcome of that practice is justified. So let's move on to more substantive issue, which is defendant's motion for partial summary judgment. So,
Yes, Your Honor. Kevin Doyle on behalf of Alan Dillard and the other defendant, Zurich American Insurance Company in this case. Can you hear me okay, Judge? I don't have my headphones on or anything.
You're good.
Very good. Now, this is a traffic accident case that happened back in 2015 on a Tuesday in the perimeter area. Alan Dillard was driving a Schindler box truck at the time. It's about 1:15 in the afternoon, which is a busy time there in that area. He moved over to the left, and his vehicle came into contact with the side of Ms. Crispin's vehicle. At that point, he turned out of the intersection, stopped the vehicle. He called 911. The police came, and the police investigated the accident. And he was cited simply for, wrongfully merging into that lane. And in this case, defendants have admitted breach of duty, and we're contesting damages, approximate cause and damages in this case. In the complaint, the plaintiff alleged that Alan Dillard somehow ran from the scene, and then that was the support needed to show bad faith in regard to 13.611, which, as you're probably aware, states that expenses of litigation generally shall not be allowed as part of the damages, but where the plaintiff has specially pled and made a prayer therefore, and where the defendant has acted in bad faith, has been stubbornly litigious, has caused the plaintiff unnecessary trouble and expense the jury may allow them. Now, the bad faith that you have to show, if you could show bad faith in every traffic accident, that would be part of the claim in all these cases that we have here in Fulton County, but you just normally do not have that. You got to show that's bad faith in the transaction at issue. So you can't argue that, oh, he was in bad faith during these other transactions, during these other traffic accidents, or in other traffic accidents. And so in the response brief, the plaintiff is arguing that somehow there was this pattern of improper driving, and that somehow that should be part of the case. Well, I mean, that's really just character evidence. And you're not allowed to get character evidence in a traffic accident case to argue that Mr. Dillard was involved in 2 prior instances, driving infractions, and so he was driving properly at the time of the case. We've already admitted breach of duty, so that's not an issue in the case. And really, what the plaintiff is trying to do is attack Mr. Dillard's character, argue about other incidents that he was involved in before and after the accident, which have nothing to do with this case. The plaintiff also cited bunch of DUI cases. This is not a DUI case. There's no evidence that Mr. Dillard was drinking at the time of the accident or had drank before the time of the accident. The plaintiff also cited several punitive damage cases where punitive damage was alleged. Now, to their credit, they didn't allege punitive damage in this case, so because there is no claim for punitive damage in this case. This is an ordinary traffic accident that happens in Atlanta every day. The other prong, you can get attorney's fees for stubborn litigiousness, which is hard to say. But when there's a bona fide dispute as to damages, you cannot show stubborn litigiousness. And in this case, this is a classic pre-existing conditions case, actually. Ms. Crispin went to a doctor before the accident, within a year of the accident, had a cyst in her back. She had an MRI, and the doctor recommended surgery. She elected not to get surgery, had the accident. She didn't feel any pain until 10 days after the accident. And then she sees Neil Flint, goes see a doctor, Dr. Moore. Dr. Moore performs the same surgery that the prior doctor would have performed. And so it's our position that her back problems and whatnot are simply not related to the accident. And so we have a bona fide dispute of damages. So you can't get attorney's fees in that situation. So in conclusion, Your Honor, this simply is not a bad faith attorney's fees case. It's a traffic accident case. When we trial the case, we're going to be trying it on just the issue of causation and damages. And evidence of other acts or whatever of Alan Dillard are simply not relevant in this case. So therefore, the defense respectfully requested this court grant defendant's motion for summary judgment as to the attorney's fees claim in this case.
All right, thank you, Mr. Doyle. Let's hear from Mr. Evra.
Thank you, Your Honor. I just have a few things I'd like to say about facts, but I won't waste the court's time too much. The complaint itself, and I'm looking at it right now, paragraph 43, it doesn't say that the only reason we're bringing a bad faith claim under 13-611 attorney's fees is because Mr. Dillard fled the scene. After we conducted discovery, we realized that wasn't the case. So we're no longer saying that's the bad faith at issue here. What we said in our complaint is because, among other reasons, Dillard fled the scene, therefore acted in bad faith. There are those other reasons are things we learned while in discovery. In that regard, what we're looking at here is a pattern and policy of dangerous driving conduct that Mr. Dillard did not only before this incident, but after this incident. And it's not just various different traffic ordinances that he violated. It's the same one over and over and over again. In this case, he was convicted of improper lane change from an April 7, 2014 incident. Of course, our incident happens June 9, 2015, improper lane change with a wreck, which caused Ms. Chrisman's injuries in this case. After that, December 14, 2017, another improper lane change, which he was convicted of. And then May 23, 2018, an improper lane change indictment, which we provided Your Honor with. Of course, that improper lane change was kind of subsumed into the other more serious allegations of fleeing and eluding a police officer, possession of firearm during commission of felony, and guilty of obstruction of a police officer, which he pled guilty to. But it shows a state of mind. It's not character evidence. Character evidence would be, we're saying that he did these other incidents, therefore he did this one too. We're not saying that here. What we're actually saying is this person has, and if you look at 404B, it lists the exceptions for character evidence. This person has the intent to commit this type of act. He knew it was wrong. He had a dishonest purpose or a conscious wrongdoing, which shows that pattern or policy of dangerous conduct, i.e. in this case, improper lane change over and over again. Now we did cite, because there are really only court opinions on this dangerous driving pattern or policy, there's only appellate opinions really on DUIs, but it doesn't restrict, those opinions don't say this is only restricted to DUIs. It could be other dangerous driving conduct as well. Recently, Judge Taylor in Fulton County issued an order against Jimmy John's, and I've got that order here that I can provide to the court after the hearing, but essentially what Judge Taylor said was, in that case, it involved Jimmy John's bikers, a biker injuring a plaintiff on the sidewalk because they were riding on the sidewalk. Judge Taylor allowed in evidence of both other incidents before and after involving Jimmy John's bikers riding on the sidewalk. Had nothing to do with DUI. And I can provide that order to the court. It's got pretty good reasoning for why that should be allowed in. But we're not using this for character evidence. We're simply showing his state of mind at the time of this incident. And that's allowed in attorney's fees claims like this one. DUIs, just saying like these are only DUIs that are allowed in, is just an arbitrary distinction.
Well, I have to push back a little bit on the arbitrary distinction. It seems to me that the general rule is that prior incidents don't come in unless there is, a pattern of dangerous conduct or reckless conduct. And I tell you, just from a sort of a common sense layperson point of view, when I think of failure to maintain lane, that doesn't immediately spark dangerous driving. And yes, I understand the allegation that it caused a serious injury here, but when I look back at the other incidents that are cited, I don't see any evidence of prior conduct that was reckless enough either to get a citation or to cause any actual injury. And I think if I look at these other cases, the touchstone of the cases where they've allowed these similar incidents to come in is where there's evidence of conduct that can actually kill people, that can actually maim and kill people. That's why there's been a general policy that prior DUIs can come in on that issue, and where reckless driving comes in. But I tell you, I'm not seeing this here. How come this just isn't a negligent and careless driver?
Well,
I mean, the penalty is you get points on your license, you get your license suspended or revoked, you get your insurance canceled, nobody will insure you, you lose your job. I'm trying to figure out the bad faith, which is akin to willfulness and wantonness and recklessness that would support a punitive damages claim. I'm trying to figure out how this conduct rises to that, especially when I don't see a case that's on point where anyone has really gone this far.
and I understand Your Honor's perspective on that. I will just caution you, if the idea is that this isn't dangerous enough to kill somebody, what you didn't hear from Mr. Doyle is that this gentleman that we've sued drives professionally for a living in giant box trucks, including the one that he was driving in this incident. So when he's getting these tickets, he's driving these giant box trucks, in this case, a steel elevator company box truck, in and out of his lanes and causing, these are all convictions. These aren't just citations. He's convicted of all these prior and post-incident improper lane changes, convicted of this one in this case. It could kill somebody. And I understand there's no case on point that says you can't bring these in, but there's no case on point that says you can't either. It's just a matter of Your Honor's interpretation of the opinions themselves, but I don't think any of them say you can't bring in improper lane change as a basis for getting attorney's fees for bad faith.
Yeah, the issue is that sort of the general rule is that it doesn't come in. So if I'm going to create an exception to the general rule and I don't want to get reversed by the Court of Appeals, I better have some solid doctrinal basis for that. And I'm just not seeing that connection, at least in the cases you cited or in the fact pattern. This person is injured people in a box truck before by failure to maintain lane. That's an issue both for him and for the company if they had prior knowledge of it or should have known about it. And I'm just not seeing that in the record.
I understand Your Honor's perspective. Would it be all right if I forwarded a copy of Judge Taylor's most recent order so you can take a look at that before making your final decision?
I will let you send it to me and I will take a look at it, but I'm sort of telegraphing to you where I'm going. The facts as you recited them to me seem somewhat different in terms of, the potential for causing injury to someone who's walking on a sidewalk and you're riding a bike on a sidewalk, contrary to the rules. I see a direct connection, a more direct connection there. So, I'm not sure it's on point, but I'm happy to take a look at it.
Okay, thank you, Your Honor. That's all we're asking for is just.
Your Honor, if I may, just for a minute, I know I feel like I'm preaching to the choir here, which is good from my perspective, of course. These other prior incidents too, I believe they were in his own personal vehicle. Schindler is not a party to this case. So this is not a negligent entrustment case. So we don't have any, the prior issues have nothing to do with this accident, are completely irrelevant. Plus, if there were no low convictions, that doesn't come in either. But this is not a case. I love Judge Taylor. Last case I tried with Judge Taylor, I disagreed with him all the way through trial, and he finally granted my directed verdict, you know. And so I love Judge Taylor to death, but we're all not always right. But I'm confident in this case, Your Honor, that the reason we don't have cases on this issue is because it's simply not allowed. So that's when you're looking for cases, you realize, well, you know, that gives you an idea of where the law is on this issue. So we just respectfully request the court grant this motion for a partial summary judgment. All right, I'm going to reserve on it for now. I'm going to read the case the order that Judge Taylor decided. Unless there's something in there that's amazing that causes me to completely rethink this, the motion is going to be granted.
Understood, Your Honor.
All right. Thank you, Your Honor. Are we excused? Thank you both. You may be excused. Thank you, Your Honor.
Thank you, Your Honor. Good seeing you, Kevin.
All right, take care, Keith. All right, let's go to Anunka versus Atlanta's Best Gutter Cleaners.
Your Honor, Evan Mermelstein on behalf of the defendant, Movant.
All right. Do we have plaintiff's attorney?
Mr. Rouse is on. I don't know if I can hear him, but he's got a square.
Mr. Rouse, can we hear you?
Good morning, Your Honor.
Mr. Rouse, we got a
Can you hear me? Yes, Your Honor.
I can't see you and I can barely hear you. Why don't you try to sign off or restart?
Yes, Your Honor. Can you hear me now?
That's a little bit better.
Hello?
That's a little better.
And Your Honor, I believe Mr. Rouse informed the court, and he certainly informed me. I think he's traveling today, so I don't know that he's got his his setup the way I do. But again, I think
Your Honor, can you hear me? Can you hear me?
We can barely
Okay.
hear you. You're going in and out.
Your Honor, I can hear you. Okay, I can hear you just if a bad spot. Can you hear me now?
That's a little better.
Okay.
That's better. Don't leave that spot.
I'm staying stationary right now, Your Honor.
All right, that's a good spot. Stay in that spot, and I can hear you, and you can hear us. So,
Okay.
Let's go through it.
Okay.
Excuse me, Your Honor. This is the court reporter. I had asked at the very beginning, I just thought I should ask again with more parties on, if anyone else is wanting takedown today.
Your Honor, I don't think I need takedown for the plaintiff.
I'm in agreement as well, Your Honor. We don't need it.
Okay. Okay, thank you. Thank you.
All right, so let's talk about this. We've got a motion to dismiss or the alternative compel discovery. Now, I see in the papers a representation that the discovery has been responded to. Is that correct? Or Mr. Bernstein, is there something that you contend has still not been provided?
Plenty, Your Honor. I guess the short answer is, you know, this is a case that started out several years ago. It's a 2017 motor vehicle accident. Originally, we filed discovery, and that was not responded to, and that case was ultimately dismissed without prejudice and then refiled. The same exact discovery was served back in November, and no responses were filed. We sent a 6.4 letter, still no responses. We then filed the motion, I guess, in February. to dismiss or compel. We have received, I think March the 10th, I received an email from Mr. Rouse that attached some documents. I then got an email from your law clerk in June asking if we had received everything. And I said, not to my, view. We never received actual service copies. It was all email, Google Drive, Dropbox. So sometimes you're not sure exactly what you're getting and what you're not. I've not received a physical copy of anything. So when I responded to your law clerk, we then received additional tax records in July of 2021. As far as we're concerned, Your Honor, there has been no statement about what is being claimed as far as actual dollar amounts. We asked for an itemization of the medical expenses. That has not been provided. We asked for a computation of damages. That has not been provided. We have received certain medical records and bills, but again, we're just kind of shooting in the dark as far as what exactly is being claimed in this case. The second thing is we asked for, there's potentially a lost wage or lost earnings claim. We asked for tax records for the 3 years before the accident and then 2 years after. We've received the year of the accident and we've received 2019 and 2020, but we have not received any of the other documents that we requested.
For plaintiff's part, Your Honor, the plaintiff has provided a complete response to discovery. Obviously, we're aware that we have a duty to supplement if new documents become available. And when I say new documents, I mean if the plaintiff at some point recommences medical treatment for her injury. This is not the most complicated personal injury case. This is a case where she had limited treatment with a chiro. She had emergency treatment at Northside Hospital. What was produced was exactly what was provided to me and what I obtained. And that included Northside Hospital records, very limited records from Northside Hospital, Metro Ambulance or EMS kind of bills associated with emergency transport, the police report. I had tax records from 2017 through 20. I had W-2s from 2019 through 20. I had my client's resume, which detailed her employment history. And she had her most significant treatment was with Atlanta Sports and Injury Center in Stockbridge. I included those records as well. I believe it was close to 40 pages of records from Atlanta Sports and Injury Center. And the bills detailed expenses totaling $6,234.00. And I believe that's actually stated in the complaint. That is at this point past medical specials related to this injury. And the responses, while late, definitely confirm that information. And in my response brief, which actually was a response to the motion to dismiss and plaintiff's motion for default, I guess the motion for default hasn't been scheduled for today, but within our response, I indicated that the complicating factor for me in this case was my client actually has relocated from Georgia to Texas. Communication between my office and my client had it some of her. I did forward those records to opposing counsel.
So let me go back to you, Mr. Mermelstein. What are you looking for from them that they have in their possession now, that you believe they have in their possession that they have not provided?
Your Honor, and again, I don't know that the defense's job is to figure out what the plaintiff's claim is all about. If all they're asking for is $6,200 in medical bills, I believe we have that. But we don't have any Northside Hospital bills or records. That's the ambulance bill and the chiropractic bill. If they're not claiming lost wages, then that's fine. Again, we're kind of, like I said, we're kind of shooting in the dark because I don't know exactly what they're claiming. And the whole point in discovery is is to understand what's being claimed so we can then request the appropriate records. And so I don't want this to be well, now we're going to supplement and here's some additional information. And again, this has been going on since the original case was filed in 2018, I believe. And so, it's a history of this. We still don't have any verifications from the plaintiffs that these are true and accurate answers. Again, it's
so you propounded interrogatories and you've gotten some documents and you've gotten written responses to the interrogatories, but you haven't got a verification.
We haven't gotten a verification and we haven't gotten confirmation as to what exactly was being claimed in the responses until today.
All right, so Mr. Rouse, that's got to be in writing and it's got to be verified. Because we've got a hold.
I'm sorry, Your Honor. I didn't mean to speak when you were speaking, Your Honor.
That's all right. Go ahead.
To my understanding, in my place, again, I'm not looking at my file and my complete electronic file, that is. But my recollection is that I thought that it included a verification from the plaintiff. If I'm in error on that, then obviously I can correct that. But I believe that the responses were.
So, Mr. Rouse, are you making a lost wage claim here?
And I'll also state that I think that was pled in the complaint is in relation to my client's discontinuation of work because she was sedentary after the accident. Certainly, that's something that my client will testify to. My client has been available for deposition. And, she hasn't been unavailable. And so, but no deposition has been taken at this point. But I'm sure my client will testify plainly to that fact that she had an injury that caused her not to be able to, ambulate and move around normally. So I'm sure that there is a lost wages portion or component to this case. It's not extreme. This is not $1 million case, but certainly her injury was significant enough for her to lose time from work. So yes.
All right. So here's what I want to happen. I think it's definitely been a little bit loose in terms of discovery. When issue was first joined on this, Mr. Townsend filed an order directing entry of a case management order in this case. No case management order has been filed as far as I can see in the record. So we need to get this on track with discovery deadlines.
Yes, Your Honor.
So that we can tie this down, get a definite deadline to conclude discovery and to get the case ready for trial. So I'm going to ask you both, counsel, to meet and confer, and within the next 10 business days, submit a joint case management order.
Yes, Your Honor.
And once we've got those deadlines established, if there is any discovery issue that remains, or either side feels like they haven't got appropriate response, I want one or both of you to email Mr. Townsend and let him know that we need to have a conference. And I'll deal with every issue where it's not responded to. But frankly, at this point on what is essentially a renewal action and on what is, basically the same discovery that's been out there and outstanding since perhaps 2017, there really shouldn't be any reason why everybody can't get the other party all the information they need to understand what the claims are in this case and what's backing them up. And then either side can file whatever respective dispositive motion they want to file. But there's going to be a deadline, and if it doesn't come in by the deadline, then it's going to be out. So,
Understood.
so I'm going to reserve on the motion to compel. I'm going to let go through the process of putting in the appropriate discovery deadlines in place. Let you make sure that we've got the entire universe of documents, that we've got interrogatories with a verification on file that are fully answered to the best of current knowledge and information. And let's go from there.
Your Honor.
Yes.
Very, very briefly, I understood Mr. Rouse to claim that he filed a motion for default. I'm not aware of any motion that's been filed or served on me. And if I could get a copy of that, I would certainly appreciate it. I didn't know that had even been filed.
So he filed a motion on he filed a response to your motion to dismiss on March 10th, and he included in there at the end a request for default judgment. You do not have to file a response to that, counsel, because the motion for default judgment is denied. It's late, and any issues regarding default are waived.
Thank you, Your Honor.
All right. So that's what we're going to do for today. We'll look forward to the case management order within the next 10 days. And then, whatever is not getting responded to or remains open, let's get together by Zoom or by phone and work through those specific issues. All right.
Thank you, Your Honor.
Thank you.
Your Honor,
Excused.
one last thing for the plaintiff,
Yes.
if I might. Is there a way that I could get some written instruction as to the issue of waiver of the motion for default? Because I wasn't aware that was unintentionally waived, but I'd like to fully understand the court's position as to the factors that caused my client's claim to be waived.
So there's not an automatic entitlement to default judgment. And there is a case, and I'll give you the site in case you want to take a look at it, but there's a specific case that talks about the issue of waiver. It's Laurel Bay Healthcare, LAURELBAYE Healthcare, and it's at 315 Georgia App 474.
Okay, thank you, Judge. I will
It
look
can
that
be
case up.
waived by delay. You can join issue and participate in the case and not raise the delay. And if you wait too long and the parties have had some substantive progress in the case, then I in my discretion can find waiver. And I find waiver in this case. Because
Yes, Your Honor.
we've gone well over a year, I believe, since you knew about the issue with potential default, and it wasn't raised.
Well, Your Honor, the only, if you would allow, I mean, obviously I respect the court's position on that, and I want to read the Laurel case in greater detail. But I would just ask that if I find some argument that might perhaps be persuasive in another direction, if the court would allow at least, obviously I want to read the case first, but if the court would, I just hope that the court would not make a final ruling on that until such time that I can actually perhaps submit an explanation or an argument on plaintiff's side with respect to the factors that were raised in the Laurel case.
All right, so, what I got from your motion, it really had no legal authority. So if you want to file a supplemental brief in support of your motion, or a motion for reconsideration, I mean, you're entitled to do that.
Okay.
And, you know, and I have to give you that opportunity. But you know where I'm headed.
I do, Your Honor, and I respect the position of the court. I appreciate the instruction.
Your Honor, obviously, I still don't have the motion for default or the response to the motion to compel, but
The response to the motion to compel was electronically filed, so it's in the docket.
Okay, but it wasn't served. That I guess that's my issue. I don't know.
Well, you get electronic service also.
Okay, I don't believe I think you have to check the box, and I don't know that the box was checked, but I certainly had.
Well, go ahead. Yeah, check the docket. It's in there. It's a paragraph or two on the issue.
Okay.
Maybe a little bit more, but I had an immediate reaction to it. But Mr. Rouse is going to try and supplement and see if he can convince me otherwise. But as of now, I'm not inclined to rule in his favor on that issue.
Fair enough, Judge. I appreciate it.
All right.
Thank you, Your Honor.
Thank you both.
Okay.
Thank you, Judge.
Rest of the day. See you, Carlton.
See you later, Evan. Take care.
All right. We have Smith versus Guest, which I believe is settled. We don't have anybody on for that case, do we? All right. Hearing none. Let's go to Pomerantz versus Stankoff.
Good morning, Your Honor.
Morning. Morning. I have defendant's motion for sanction of dismissal. I tell you, this is an interesting set of facts here, so I'm very anxious to hear both sides of this issue.
I'll take it away, Your Honor, as the movement. Nathan Hoffman here on behalf of the defendant, Peter Stankoff. We are here today on our motion seeking the sanction of dismissal for plaintiff's willful discovery abuses. I want to preface today's hearing with that this isn't a spoliation hearing. This isn't a hearing on our currently pending motion to compel. We're here today because the plaintiff lied and made multiple attempts to hide pivotal evidence in this case. He did it under oath, and it isn't until his prior counsel brings to light his deception that we find out about this video. This isn't a day where we talk about misremembering and then correcting the record. It's lying under oath, trying to bail yourself out of hot water. I think our brief was pretty transparent with the facts of this case, but because today is pretty fact intensive, I am just going to recap. This case is about a car accident that occurred April 26, 2018. My client, Mr. Stankoff, did rear end the plaintiff, Mr. Pomerantz. It's been our position for the duration of this case that Mr. Pomerantz was driving erratically and stopped short. Before the dash cam video came to light this May, this was going to be a he said trial if this case proceeded to trial. You know, what we know now is that at the time of this collision, Mr. Pomerantz had a dashboard camera operational, functioning, and recording at the time of this collision. Now, plaintiff's brief in response to our motion for sanction makes much to do about Mr. Stankoff's insurance company taking possession of the vehicle. He claims that the dashboard camera memory card was back in the dashboard camera when the insurance company took the vehicle. But really, that's a non-issue on this motion because this isn't a discussion about spoliation. It's about plaintiff's willful discovery, abuses, and deceptions throughout the pendency of the case.
But let me ask this question. Did the defense have the video in its possession? They had the actual camera and the video in its possession at some point in time. Is that right?
Your Honor, the insurance company did take possession of the vehicle 14 days after the collision occurred, but there's no evidence in the record that the insurance company knew there was a dashboard camera, knew that it had been recording, knew that it had been placed back in the vehicle. It's just, well, they took the car and now we're saying the dashboard camera was in it. So of course they had the video, but there's no evidence of that.
All right.
So what we know is that the plaintiff changed counsel from Mr. Stephen Jackson to Mr. Kratzer's law firm in June of 2019. And if we are to believe the affidavits that were submitted in support of the response and opposition for the motion for sanctions, the pivotal evidence, the dashboard camera video, was not transmitted and was not inquired about once the case transferred hands. Ultimately, suit was filed on March 30 of 2020. And we've had 2 hearings already on bad faith issues, but I do just want to point out that from the outset of this case, my client, Mr. Stankov, has been paying out of pocket for conflict counsel because plaintiff's counsel has refused to negotiate policy limits because he thinks this is a bad faith case. Now, you've ruled twice that we're not doing discovery on the bad faith issue. I don't want to talk about it anymore today if we can avoid it. Written discovery was exchanged at the outset of this case. And from the outset of this case, my client has put forth liability and causation of the collision defenses. You can rear end somebody and have it be their fault. And it's the job of the jury to make that determination based on all the evidence. It's not up to the litigants to say, well, he rear ended me. Of course, it's all the way his fault. Plaintiff's initial responses to our discovery requests, which were interrogatories and requests for production, those were served on us on August 17 of 2020. That was after the judicial stay. So our initial discovery was served on April 30th, but because the COVID stay, responses were timely made on August 17. Plaintiff's verified interrogatory responses stated, in response to us requesting what evidence had been preserved for trial, that 44 photos were preserved and that dashboard camera video footage would be produced. That video was not produced. On September 17, 2020, plaintiff's prior counsel, Mr. Stephen Jackson, filed a motion to intervene to protect his attorney's lien in the case. That is going to be important later today in our conversation. We deposed the plaintiff in October of 2020, and Mr. Pomerantz, under oath, testified that no video has ever existed.
So was there any explanation given as to why the written discovery response says there is video and he's saying there's no video?
Well, Your Honor, I asked the plaintiff that exact question during his deposition, and he said that his verified interrogatory responses were incorrect. I can pull up I have the transcript right in front of me.
The real explanation here.
Sorry, Your Honor, I didn't hear you.
Yeah, I did read that, but that just doesn't go far enough. Why were they? You have any idea why they were incorrect? Because the thing I'm struggling with is the motivation to lie. Why would you, after you've already disclosed there's a video, why would you even disclose it in the first place if there was intent to conceal the existence of the video?
Well, Your Honor, I can't really go to the plaintiff's motivation. Those would be communications between him and his attorney potentially, and those are protected by the attorney-client privilege. I think today is part of the inquiry today is a fact-finding determination on your part to find out what that motivation might have been. From where I'm sitting, the motivation to suppress this evidence is because the dashboard camera video directly contradicts his story in this case, I think. And again, I don't want to get
because I haven't seen this video. Tell me how you believe the video directly contradicts his story.
Well, Your Honor, the plaintiff's narrative in this story is that this was a major impact, that he was driving perfectly safe, that he was completely stopped at the time of the collision, and that he has absolutely no fault in the collision. What the video actually shows, and again, I don't want to get too far into the probative value of the evidence because really that is for the jury at the end of the day. But if this case proceeds to trial, I'm going to put that video in front of the jury and it's going to show that the plaintiff is speeding past the cars in the right lane from him. There is a school bus with the stop sign extended. The other vehicles to the right of him are stopped. He's zipping right past him. And at the last minute, he slams on his brakes. And before he's even at a stop, even though he's been consistent in his story that he was at a dead stop and was slammed into, his vehicle's still moving. There's a light impact. His vehicle barely moves forward. And this video shows that. and it completely contradicts his narrative of the story.
So do you contend that there is some other part of the video that's material that has been erased or withheld? Because it sounds like that video gives you all the evidence you need to contradict his story.
Well, Your Honor, it does contain what we believe is probative and pivotal evidence. You can tell from the video that we have, it's actually a recording of a recording. And the video starts with the time bar 3/4 of the way through the entire recording of the dash cam that day. My client's testimony at his deposition was that he had been following behind the plaintiff for quite some time, and that the plaintiff was driving erratically throughout that time. Also, my client's testimony at deposition was that after the accident, Mr. Pomerantz was up and walking around and had moved his vehicle before the police arrived. That would also be demonstrated by the additional video that we know exists, because the photos that were produced based on the video show more photographs after the cutoff time of the video. Simply put, there's more out there and it's important to this case. And it's not up to the plaintiff to decide if it's important to the case or not. So, Your Honor, after we get through plaintiff's deposition and he testifies that he's never seen a video, the video doesn't exist. Even when asked by his own attorney, he says there was never a video, there were only photos. Files or serves amended discovery responses that conform to that testimony. After the deposition, we issued requests for production of a request for an inspection of plaintiff's electronic devices, because frankly, I didn't buy the fact that this dashboard camera only took photos. I believe there was probably video out there. Plaintiff's testimony at his deposition was that he wasn't quite sure how the electronics work. And, I decided I would take that upon myself to find out maybe that data, the raw data from the dash cam, still exists somewhere. I got a blanket objection that this was a fishing expedition, so I filed a motion to compel. Plaintiff's counsel filed a response to that motion to compel, saying that no dashboard video exists. It was after plaintiff's counsel filed his response in opposition to the motion to compel that attorney Stephen Jackson, who had intervened in the case and was a service contact, brought to light and brought to Mr. Kratzer's attention, apparently for the first time, that a video does exist. Now, Your Honor, the only reason that we're here today is because Mr. Stephen Jackson reached out to Mr. Kratzer to point out the either mistake or omission that he had made. What we know now is that Mr. Pomerantz had seen that video. He had made a recording of that video. He had taken photos from the recording of that video. He had provided the video to his prior counsel, and still he lied under oath and then served verified supplemental interrogatory responses conforming to the same. But Your Honor, I don't.
So it seems like the implication here is that he changed this story once he changed counsel, relying on the fact that new counsel wouldn't know about the video.
You're on. You cut off. I didn't understand what you said.
It seems like the implication being made, Hoffman, is that he changed the story once Mr. Kratzer was retained, relying perhaps on Mr. Kratzer's lack of knowledge that the video existed.
Your Honor, I can't really go into the motivations or the reasons behind that. If I could do discovery on the issue, I sure would. But I can't. All I can do is say what I can see from my position. And what I see is that this video existed. The plaintiff knew about it. The plaintiff lied about it. The plaintiff did not produce it. And it's not until his prior attorney steps in and says, well, that's just not the truth. That's when the deception becomes apparent to me. And that's where I have to take action on behalf of my client. Now, Your Honor, as we pointed out in our brief, the plaintiff has only produced a hand-picked portion of this video file. It's not up to him to decide what portion of this video I'm entitled to. And plaintiff has admitted in the affidavits that he sent in support of his response in opposition to the motion for sanctions that he no longer has any of the electronics that the data may exist on. And I'm sure that Mr. Kratzer is going to try to point the finger, as he did in his brief, saying, well, AAA had the thing the whole time. But Mr. Pomerantz knew about the video footage. He lied about its existence for a month, and he deliberately allowed it to leave his possession. Is my client supposed to take this case through trial with only the evidence that Mr. Pomerantz is willing to let us have? That's not how our system works. Isn't the jury entitled to all of the evidence? And it's your job to gatekeep on what evidence comes in and what comes out. Your Honor, along with the brief in opposition for the motion for sanctions, 2 affidavits were filed, one from Mr. Kratzer, one from Mr. Pomerantz. Mr. Pomerantz's affidavit says that video files, plural, had been retrieved from the dashboard camera. So far, I've only seen one video clip. One video clip isn't files, plural. There may still be more out there. And Your Honor, the plaintiff's affidavit tries to explain how these miscommunications or issues may have come about, claiming that he had a surgery that jarred his memory, or that he had a heart attack in July of 2020, which has caused him memory issues. But Your Honor, the plaintiff admits that he produced the video file to his prior counsel after his knee surgery, which was in, I believe, September of 2018. The affidavit states that the video file was produced to Stephen Jackson in December of 2018. And as far as the heart attack, while I am sympathetic to the stress and medical impact of a heart attack, our discovery requests were served on April 30th of 2020. Mr. Pomerantz's heart attack occurred in July of 2020. So I think to try to claim that these medical issues caused a memory problem is disingenuous.
I'm still having difficulty with active concealment if he gives the video to his counsel. This is not behavior that's consistent with not wanting the truth to come out.
Well, Your Honor, the fact that he knows the video exists and lied to me about it is indicative that he does not want the video to come out. To lie about it at his deposition, to serve discovery responses that conform to those lies, and then to oppose my motion to compel seeking to look for those videos, those are all indicative of that. And what I haven't seen is any evidence that plaintiff or his counsel took efforts to explore that issue independently and determine if the video file exists or not. The only independent verification that we have about when the video came to light and who had it is because Stephen Jackson intervened in the case. If he hadn't intervened in this case, Your Honor, I'd be trying this case without the video. Plain and simple. If Mr. Jackson, who has a motion, or he's intervened just to protect his lien, he doesn't need to be reading all the filings. If he hadn't read the briefs, I wouldn't know about the existence of this video. And we would go to trial without pivotal evidence, which is exactly what 9/11/37D sanctions are in place to protect against. Now, Your Honor, I do have a lengthy quote from a Supreme Court decision, Resurgence PC versus Elliott. It's 301 Georgia 589. And that case is directly on point with dealing with deception during the discovery process. I'm going to take a sip of water before I start this one because while I don't usually like using very long quotes, I think this one is very instructive and I think it's very on point today.
Give me the site again.
It's 301 Georgia 589.
Okay, I've got it.
At what page, Nathan?
It's Resurgence PC versus Elliott.
At what page? 301 Georgia 589 at what?
I don't have it pin site. I will give you that. My outline didn't have it pin site. I apologize. It says here, when a party receives a substantive answer to a discovery request, they are entitled to believe that answer, and they are not required to file a motion to compel or seek clarification of that substantive response in order to obtain sanctions should they later learn that the answer provided was false or intentionally misleading. This is because an intentionally false response to a written discovery request, particularly when it concerns a pivotal issue in the litigation, equates to a total failure to respond, triggering OCGA 9/11/37D sanctions. Now, Resurgence goes on to quote language from Marta versus Doe, which is 292 Georgia App 532. And Resurgence quotes this portion of that case. An interrogatory answer that falsely denies the existence of discoverable information is not exactly equivalent to no response. It is worse than no response. When there is no response to an interrogatory or the response is devoid of content, the party serving the interrogatory at least knows that it has not received an answer. It can move the court for an order to compel a response. If the response is false, however, the party serving the interrogatory may never learn that it has not really received the answer to the interrogatory. The obstruction to the discovery process is much graver when a party denies having had a prior accident than when the party refuses to respond to an interrogatory asking if there had been any prior accidents. A litigant will not be heard to contend that its own conduct has removed it beyond the reach of sanctions when it has frustrated the orderly process prescribed in OCGA 91137 by false or erroneous responses to interrogatories. To condone such conduct would force parties to assume the falsity of every sworn interrogatory response and file endless motions preserving their right to relief. Such a rule would allow the unscrupulous to conceal documents from opposing parties by the simple expedient of denying their existence, without fear of penalty if the deception were by some chance discovered. It would discourage diligence in seeking out relevant documents, even on the part of those not actively dishonest. Lack of diligence or negligence would not only be unpunished, it would be rewarded. End quote, Your Honor. Now, Your Honor, I don't think that there is any dispute today that under OCGA 91137, you are authorized to take sanctions up to and including dismissal of this case. The question today is if you should, and what evidence both sides can present that either support dismissal of this action or warrants plaintiff continuing this action. Now, today, you are sort of sitting as the fact finder, and you're given broad discretion to issue sanctions because of your ability to assess the conduct, demeanor, credibility of the parties and their counsel. That authority is granted to you by the holding of Ford Motor Co. versus Conley. It's 294 Georgia 530. And Your Honor, the sanction of dismissal for failure to comply with the discovery provisions of the Civil Practice Act is permitted upon a showing of conscious or intentional act or failure to act, which is distinguished from an accidental or involuntary noncompliance. I think the evidence here today shows a conscious and likely intentional act and failure to act by Mr. Pomerantz to produce the video in discovery. I understand that it has now come out, but it is after deception after deception after deception. And it's not because Mr. Pomerantz all of a sudden said, oh my goodness, I actually do have a video. It's because his prior counsel read the briefings and said, those aren't true. This needs to be fixed. And Your Honor, we don't have to show it. And I think plaintiff's response in opposition to our motion today tries to convince the court that we need to show some sort of malice on the part of the offending party. But that's not always required before a court determines that dismissal is appropriate. Now, Your Honor, I am borrowing slightly from spoliation here, and I know that I'm trying to focus on not having this be spoliation. But when an offending party tries to argue that their conduct is less culpable than malice, well, really what you have to do is balance the prejudice to the non-offending party. And in this case, my client is heavily prejudiced by the actions and deceptions of Mr. Pomerantz. At this point, what am I supposed to do? Am I supposed to believe all of Mr. Pomerantz's, the remaining portion of Mr. Pomerantz's discovery responses and deposition testimony is true? No, I can't. At this point, do I need to send non-parties to every medical provider within a 50-mile radius of every place that Mr. Pomerantz has ever lived to find out if he has a pre-existing condition that may impact the cause of the injuries he's claiming are a result of the car accident? Do I need to send an open records request to every police department in the United States to find out if he was involved in a subsequent collision that may cause or contribute the injuries he's claiming in our accident? Your Honor, plaintiff's actions that are demonstrated in the record by evidence are exactly the kind of conduct that the courts in Resurgence and Marta found to be worse than incomplete responses. And the court in those cases found that the misleading discovery responses are sanctionable, even if corrected. Now, Your Honor, I do just want to point out some of the arguments and cases cited by plaintiff in the response briefing. And briefly, plaintiff does cite to the Marta versus Doe case that I quoted from, and cites for the premise that dismissal should only be granted if suppressed and concealed evidence is pivotal, and if the omission or suppression is discovered after the close of discovery and during trial. I think plaintiff's reliance on this case is misplaced. Because of course the video of the subject collision is pivotal evidence. Of course it is. And frankly, Your Honor, to say that I would need to have some gotcha moment at trial where I suddenly find out, oh, there is video and there's been video all along, that leads to an absurd result. You can't lie throughout the discovery process and be rewarded for maintaining your deceit through trial. Now, Your Honor, you have broad discretion when resolving the issues that I've raised today, and I believe that the conduct that we've demonstrated warrants dismissal. If this kind of conduct isn't sanctionable, what is? Litigants could make false statements about the kind of and existence of pivotal evidence and simply claim mistake later if their deception is discovered. Plaintiff and his counsel have both asserted that the video doesn't exist. And it's not until Stephen Jackson brings it to light that we find out that it does. Now, I understand that I am seeking the harshest sanction this court is able to impose on a plaintiff, and I recognize the gravity of that request. But I wouldn't be seeking that sanction if any lesser sanction could rectify the damage done in this case and preserve the integrity of the judicial system. Any lesser sanction today would basically give a green light to litigants to lie under oath, provide false interrogatory responses, and then they can just claim mistake down the road. Your Honor, words matter, but even more than that, the truth matters. And we as officers of the court and participants in the judicial system, we use the scales of justice as a symbol of our profession. Litigants who put their thumbs on the scale should not be allowed to maintain actions in our judicial system. I ask this court return the harsh, but in this instance, fair and necessary sanction of dismissal based on plaintiff's willful discovery abuses.
All right, Mr. Kratzer, before I turn to you, we do have Mr. Jackson on the line. Mr. Jackson, I have a few questions for you, if you wouldn't mind.
I'm here, Your Honor. Happy to help.
Thank you, Mr. Jackson. First question for you. I understand that you had possession at some point of this video.
I did. It was an electronic copy.
All right. When did you first get possession of the video?
Your Honor, would that not go to attorney-client privilege?
I think I'm not
I
asking
understand the question under the circumstances, don't get me wrong.
for a date, so I don't think there's any substantive communication involved in me asking what the date was that he received it.
Let me dig a little, Your Honor, into my files.
And let me be clear, I'm not asking for the substance of any communication between you and your client, just simply the fact of when you got it.
I suppose I should have anticipated this question, Judge, and just bear with me. Let me see what I can come up with.
That's quite all right. I'm just trying to understand the timeline as best I
Yes,
can.
Your Honor. I can't tell you this. I do know that I did receive that video during the period of time in which I was representing Mr. Pomerantz. And I will say that that Mr. Kratzer, when he took over as counsel for Mr. Pomerantz, asked me for all of my file materials. I provided Mr. Kratzer with all of my file materials. However, that was everything that was in like a box. It was the hard file. Would not have included electronic communications, emails between myself and Mr. Pomerantz. And I can tell you from independent memory that I'm certain that I did not provide him that video at the time that I provided him what in my mind was the whole of the file materials. then and only then, way down the line, I was actively following this case electronically because I was getting notices of everything once I'd intervened. And when I saw that said there was no video, I did what any, I think, conscientious lawyer would do. I picked up the phone. I called Nathan. I said, Nathan, I said, hey, I'm pretty sure I've got some video. If I didn't give it to you, my bad. And he asked me to dig it up. I dug it up. I found it. I gave it to him. And so far as I know, he immediately turned that over to opposing counsel. I am going to continue to try to locate that video.
But while you're locating that, were you counsel of record at the time that the answer to interrogatory number 27 was served, saying there was video camera footage?
I don't believe in, I'll defer to other counsel. I don't think that I ever even got to the point where we filed suit.
No, Your Honor, we took over pre-suit.
Yeah.
And I believe in Mr. Pomerantz's affidavit, he explains the confusion between why he answered the interrogatory that you referenced there the way he did. And I also explained that as well in my affidavit response, because obviously, certainly our client provides us with his responses, and then we try to type them up nice and pretty. And as well as a good of a job as we do, I think, as lawyers, sometimes I think there are miscommunications. That's exactly what happened. And I think we tried to explain that through our affidavit. So that's why the interrogatory was answered in that fashion.
All right, Mr. Jackson, if you could keep looking for.
I'm digging.
If you find one, just please feel free to speak up, but I'm going to turn to Mr. Kratzer for now and let him go ahead and respond.
Your Honor, I might be able to help Mr. Jackson. Stephen, my understanding from the file that you sent me after we spoke that you referenced there, it reflected a date of December 5th of 2018, I believe is what I saw on the email that you forwarded to me afterward, if that helps you for that purpose. Thank you, Your Honor. Just to start off, in terms of this whole issue of sanctions and the broad discretion, certainly you do have broad discretion. I don't disagree with Mr. Hoffman in terms of the sense of what your discretion is. However, be that as it may, the discretion issue, there are very clearly defined, I don't want to call them rules, but guidelines as to when sanctions should be and should not be appropriate, especially sanctions such as 9/11 37D in terms of dismissal. The fact of the matter is obviously, in my opinion, this motion should be denied. I contacted Mr. Hoffman on 2 occasions asking him to dismiss his motion or withdraw his motion because I felt that it was borderline on the realm of frivolous litigation based upon
that argument's not going anywhere with me. I think this is a case for me, and I don't think it points to a definitive black and white answer either way. So
I understand
that this is a frivolous motion is not going anywhere with me. There's some serious issues here. And the question is whether I believe the explanations for the conduct here, because clearly false information was given, and that false information led the defendant's counsel to have to take pretty strenuous efforts to get to the bottom of the discrepancy. There was a discrepancy, and it wasn't remedied until after a response to a motion to compel was already made.
Your Honor, I agree the fact with respect to the motion to compel, yes, a motion to compel was made. I wholly disagree with respect to the fact that this is not a easy yes or no issue because of the fact that the guidelines for purposes of sanctions of dismissal are very clearly defined. And of course, they are notably completely absent from defendant's motion. The actual guiding case law, Mr. Hoffman has yet to cite in this type of issue. Resurgence is a non-binding decision. And under the new recent Court of Appeals rules, in terms of what binding case law and binding decisions are, the most relevant case on point is the Foundations versus Home Depot case. And of course, notably, if you look at defendant's brief, Your Honor, he doesn't cite to one case that substantively tackles what the actual guidelines are for purposes of granting a motion for sanctions for and dismissing a case. In every single case in which sanctions have been ordered and dismissing the person's case, each time the cases have been in the middle of trial, they have been aha gotcha moments. Not only have the parties at issue been found to be lying and purposely holding on to evidence and purposely destroying evidence, but their counsel has been actively participating in those issues as well. Those are the cases where dismissals for sanctions have been granted. This is not the case. Despite what Mr. Hoffman would say, not only would this court have to believe that Mr. Pomerantz is actively maliciously lying, but Your Honor, the court would actually have to believe that myself and Mr. Jackson are also maliciously lying and hiding. That's the truth of the matter. If you look at the Foundations case, and I'll give you the site here in just a second, it is 855 Southeastern 2D 434. It's a 2021 case. The court found that the court must find that the offending party acted willfully. And in that specific case, there was a claim that through the course of 2.5 years, mediations, and now at trial, that the other party intentionally misrepresented the amount of insurance in a case. The court held that there was no willfulness shown because as soon as the counsel for Foundations discovered this new insurance policy, they admitted to it, they disclosed it to the other party, and they supplemented their discovery responses. Those are exactly the things that happened here. The other case that's also on point here is Marvin Hewitt v. Butler Capital, 328 Georgia App 317. It's a 2014 case. Their sanctions were denied because the alleged offending party had stated that they had given, there was an allegation that false responses had been given in terms of what property names had been issued in terms of the discovery responses. The court held that there was no willfulness again on the part of the offending party because there was a significant similarity in the different names that were being proposed or being cited to in terms of what the issues were in that case. Another case on point in terms of sanctions is Everson v. Phoebe Sumter Medical Center, 341 Georgia App 182. It's a 2017 case. We're talking about a wrongful death action. Initially, the tragedy of this case was that a gentleman came into the hospital. He was then transported from the hospital to a psychiatric facility, but on the way to the psychiatric facility, the person driving him got into an accident, he died. There was an alleged malpractice for them taking him to the psychiatric hospital. The issue is that there was confusion as to whether or not he had actually been seen at this hospital initially. And the discovery responses indicated that he had not been seen, even though there was a hospital record of him being seen at this hospital. There, again, the court said that as soon as the counsel learned of the error, they denied the motion for sanctions because not only did they provide amended discovery responses as soon as they learned of the error, there was affidavit of counsel indicating that there was a mistake and that they corrected the mistake immediately. And they made the comments of counsel in open court that there was a clear misunderstanding as to what actually had occurred. That is no different than what we have in this case. And notably, I understand that Mr. Hoffman does not want to talk about spoliation, but if you notice, 40% of his brief's case law is about spoliation. Of course, there's only 5 cases cited in his entire brief, and I don't understand why that is, except for the fact that there's not one case on point that actually helps him in this arena, and he knows that. I contacted him over the phone and I told him this. I said, Nathan, there's not one case here that actually supports your position. Not only do you have to believe that Mr. Pomerantz is a liar, you also have to believe that I'm a liar. And he told me specifically, I don't have to believe everything you're telling me. I was like, you know what, you're right. But I'm providing a sworn affidavit as an officer of the court, telling the court exactly what happened. As soon as I learned of this, I immediately withdrew our response to the motion to compel, because I knew that we had to, because obviously we had the evidence there. We then immediately provided the evidence and amended discovery responses, and we transmitted it over to defense. There is no rhyme or reason for us to even have hid this video, despite Mr. Hoffman's description. And I believe that we sent the video over to Mr. Townsend for y'all to view. There's nothing in that video that it is what it is. There's not a gotcha moment for any side, to be quite frank. And Mr. Hoffman has yet to elicit exactly what it is that he's seeking in terms of, I guess, potential video afterwards. Obviously, we provided, I guess, what the screenshots were in terms of the actual video after the fact, but that's exactly what was provided to Mr. Jackson, which was then provided to us and we transmitted. So the fact of the matter is, I don't know what exactly it is that he's looking for. I took Mr. Stankov's deposition, and Mr. Stankov admitted that he saw our client's brake lights, despite this allegation that our client was driving erratically and driving extremely fast. Well, then by implication, Mr. Stankov had to have been driving erratically and very fast for him not to have been able to give enough distance when he saw the plaintiff's brake lights to not be able to not hit him. But he said he saw his brake lights. He did not dispute that he was at fault for the collision in any way, shape, or form in his deposition. And he did not say that he and Mr. Pomerantz had any sort of meaningful conversation afterwards. Mr. Pomerantz did not testify to any meaningful conversation afterwards. So you don't just have to take Mr. Pomerantz's word for it. You take Mr. Stankov's word for it. Mr. Pomerantz admitted that he moved his vehicle afterwards to a neighborhood to the side street. Mr. Stankov testifies that Mr. Pomerantz moved his vehicle to a neighborhood on the side street to get out of the way there on Holcomb Bridge. Both stories line up. So the motivation here to lie is just absent. Subsequent to that also, Mr. Hoffman put Mr. Pomerantz's health at issue here. The fact of the matter is that, yes, our client has gone through one knee surgery, a hand surgery, and a major heart attack in the course and scope of these 3 years. I can state my place. My father was suffering a heart attack when I was 10 years old. He was not right mentally for 2 years with his memory. So that being said, I understand we're in a court proceeding. I understand that we need to give truthful and honest answers to the best of our recollection. We have provided the discovery to Mr. Hoffman. We are continuing to provide discovery to Mr. Hoffman. If there was willfulness on the part of the plaintiff, then I would have told Stephen when he called me and said, "Who's this?" and hung up the phone. But as soon as he told me, he's like, "Hey, Nathan, it looks like I do have a video here." And I said, "Well, I got to give it to Nathan then." Not me in the third person, but Mr. Hoffman. So the fact of the matter is we've been above board throughout the entirety of this process. Mr. Hoffman, on the other hand, knows that he has this one last card to play in a clear liability collision in which to try to muddy the waters and somehow point the finger in another direction to make our client come off as somehow as being lying, misleading. But the fact of the matter is whether he wants to admit it or not, if he's going to continually call my client a liar, he's also invariably calling us liars as officers of the court, even though we provided affidavits saying what exactly happened. All of the case law that Mr. Hoffman points to does not address what conduct constitutes dismissible, sanctionable conduct for purposes of discovery abuse. This is not any of those cases. In Hernandez v. State of Georgia, 200 Georgia App 368, the general rule announced was that the trial court should attempt to compel compliance through the use of lesser sanctions and imposition of drastic measures under OCGA section 91137D. Camira Inc. v. Amory, 210 Georgia App 48, sanctions authorized under subsection D should be applied only in the most flagrant cases where the failure of discovery is clear. Smith v. Molinax, 122 Georgia App 833, and Bells Ferry Landing v. Wirtz, 188 Georgia App 344. Only in cases of a conscious or intentional failure to act is distinguished from an accidental or involuntary or non-compliance merit dismissal for discovery sanctions. I don't dispute, based on what has happened, if Your Honor felt that we owed court costs for purposes of Mr. Hoffman having to file that motion to compel, I would not disagree with you, because the fact of the matter is, we ended up he had to write that motion. We responded to it, and now we're here. I don't dispute the fact that that's why I immediately withdrew our response to the motion to compel. I can understand that the court would order us to pay his fees for having to write that motion, because he shouldn't have had to. I can also state my place, though, that when I received Mr. Jackson's file, as he indicated, it was a large box of information. I went through it thoroughly. And I have to be very complimentary to Mr. Jackson, because he has incredibly detailed case notes. And I went through and made notes based on those case notes. And even though Mr. Jackson had a ton of stuff in there, it was just notably the date where the video was given, and that was, I saw in that email there, it was not in those case notes. I went through everything. And Mr. Jackson and I even talked about this. You can ask him about it. I know it was an oversight. And as soon as that oversight was noticed, and I'm grateful for Mr. Jackson's intervention in this case so that we can get this to come to light, because now Mr. Hoffman has this video. I do want to go to the fact that, again, the only reason we're here is because Mr. Hoffman, his client's insurance carrier, had our client's vehicle. The claim notes indicate that the entirety of the vehicle was taken on May 10th of 2000 and I believe 19 or 18, some 2.5 years ago or so. The dash camera was attached inside the vehicle. I asked Mr. Hoffman, and in Mr. Pomerantz's deposition, he testified that that's where the dash camera and the memory card and everything was. I asked Mr. Hoffman on the phone not a couple weeks ago, hey, did you send any non-party requests to AAA Insurance to see if they had the video, if they still had the car, did they preserve the car? Based on Mr. Hoffman's motion, litigation was contemplated at that time. So that would indicate a duty to preserve on AAA's account, their insurance carrier.
We're getting into spoliation.
I agree. That's exactly what Mr. Hoffman brought up. I think I need to address it. He wants to get in the back door when he can't get through the front. So I feel I still have to address it and make sure that that area is secure.
You don't have to address the spoliation part. I'm not even considering spoliation right now.
I agree. That being said, the fact of the matter is, no matter what, the evidence still technically was in the possession of defendant and his agents as of May 10th of 2018. Mr. Hoffman never sent non-party requests over to AAA Insurance.
Yeah, let's move on from that. I got your point. Let's move on from that.
All right, and I'm not even talking about that in the context of spoliation. That, to me, is that in the end of the day, if he has evidence in his possession that he already has, and now he's trying to sanction us for discovery, well, he should have had it anyway. He should have gotten that from his defendant's insurance carrier, and he didn't. He's not made any non-party requests. He didn't mention it up.
You've already said that. Let's move on.
Your Honor, the evidence in this case from that video, and I'm glad that it was sent to Mr. Townsend. I'd like for Your Honor to take a look at it. It's not dispositive. It's not pivotal. We have a rear end collision. You have a video that's facing somewhat, I would call it, I guess maybe to the 1 o'clock area. You can somewhat see a jarring effect. But he doesn't have a rear dashboard camera that's facing the back and shows Mr. Stankoff hitting him from behind. It shows the front of the vehicle. It's not dispositive as to whether or not he was following too closely. It doesn't point to his actual speedometer to show what speed he was going. It shows nothing that's pivotal to this clear liability collision that his defendant Stankoff says he is responsible for causing. The incorrect discovery responses, Your Honor, were not willfully made. There's not been one instance in my tenure, both as a assistant district attorney or as a civil trial lawyer, where I have ever misled the court or told anything untruthful to a court, and I won't do it, and I won't do it 100 years from now. We got the correct information. We provided it to the court. If we were trying to hide it, Your Honor, we never would have provided it. The motivation to lie and to act willfully and to actually commit discovery abuse would be to continue to hide it. And we didn't do that because as soon as we found out that there was that information there, we provided it to him. And in fact, in Mr. Pomerantz's affidavit, he still doesn't even remember looking at that video file. Certainly, even though, as you said, that you're not considering spoliation, there's not been the spoliation of evidence. The evidence is out there. We have the evidence. There's not an issue of prejudice because they have the evidence in front of him. Mr. Hoffman may not like the evidence, but as Judge Ott told me many, many years ago when I was first practicing, lawyers are not magicians. We can't just go poof and make something that we don't like disappear. You have to deal with the facts that you're given. And unfortunately, if Mr. Hoffman doesn't like the evidence, I can't help that. Sometimes I don't like the evidence. But the fact of the matter is that he's got it. He's got to deal with it, just like I have to. There's not been any prejudice, Your Honor. They've had this evidence from May 10th of 2018. Now they're claiming that they've just gotten this and that they're incredibly prejudiced. I don't doubt that that's why they're making the argument, because they know that this is a clear liability case and this is the last string that they have to pull in this matter. It has been from the get-go that there's been no dispute that Mr. Stankoff followed too closely. In fact, if you noted in his opening, Mr. Hoffman said, there's no question that our client struck the rear of Mr. Pomerantz's vehicle. He then said that he was driving erratically and that he stopped short. Your Honor, there's not anything in the code sections, there's nothing in the case law that says that just because someone stopped short, that's an excuse that you hit him from behind. The rule is you have to leave enough distance that in an emergency, you can stop without striking another individual. This made up defense that our client stopped short, whether he did or he didn't, doesn't matter. That doesn't abrogate the absolute rule that you still have to keep an assured clear distance. Mr. Hoffman knows that. He's a good lawyer. He knows that. And he's grasping at straws. Your Honor, the other issue is that under Marta v. Doe 292, Georgia App 532, they define total failure because, quite frankly, total failure to respond is what is in the code section. The courts have expanded upon that as to what total failure means. Total failure also includes malicious, conscious, and intentionally false discovery responses. As I said before, for you to believe and to get to that point, you not just have to believe that Mr. Pomerantz is lying, you also have to believe Mr. Jackson's lying, you also have to believe that I'm lying and being untruthful to the court. All right, that is, I can say my place, that's not true. I believe that Mr. Jackson is telling the absolute truth. I provided affidavits of the same, putting myself on the line for the same. I know that misleading the court could lead to my disbarment. Notably in the Marta case too, Your Honor, the sanctionable conduct there was, yet again, found in the middle of trial. We're in discovery. And we provided it in discovery.
All right, Mr. Kratzer, I think I've got your argument. I think we're getting into points where we're repeating earlier points. So let me give you another 2 minutes to wrap it up, and then I'll give Mr. Hoffman an opportunity to have the last word.
Your Honor, if I could just jump in for 1 second, just to be responsive to your inquiry earlier, Judge. Looks like the incident occurred, the collision occurred April the 26th, 2018. I received the video from Mr. Pomerantz 12/5, December 5th, 2018. And I provided the hard copy file to, I received an email from Mr. Pomerantz on June the 14th of 2019, asking me to provide a copy of his file to his new counsel who would be reaching out to me. I'm certain that Nathan and his staff then did reach out to me. I made a copy of the file. I gave him the file, and that was that until, after I had intervened and I saw that response to the motion to compel. And that's when I immediately called subsequent counsel and provided him that video.
All right. Thank you, Mr. Jackson.
Thank you, Judge.
Your Honor, I point to one last case here that I think is notable is Howard v. Allegria, Georgia App, 321 Georgia App 178. It's a 2013 case. In that situation, a defendant denied existence of onboard recording devices and also that they were covered by excess coverage and also that they had not spoken with several witnesses and obtained documents from those same individuals. It came to light in trial that not only did the defense fabricate that information and willfully destroy information, but again, the actual counsel for the defendants were implicated as well as actively participating in that destruction of evidence. And that was considered sanctionable conduct enough to warrant dismissal. There is not one case on point noted from Mr. Hoffman that actually addresses what the kind of the facts that we have here, because there are none. There's not been one Court of Appeals or Georgia Supreme Court decision that indicates that conduct that we have in front of us is sanctionable for purposes of dismissal. Your Honor, as soon as we gave him that video, or as soon as we learned of the video, we gave it to them. I think that goes to show our good faith. The fact of the matter is I think once you review the video with Mr. Townsend, it does not help the defense. I don't know that it hurts them. I don't know that it helps me. I don't know that it hurts me. It is what it is. So the fact of the matter is there's no prejudice whatsoever there. It doesn't meet any of the bullet points or guidelines for purposes of sanctionable conduct that warrants dismissal. In this case, Your Honor, I understand that it's a very interesting set of facts, but if you review the case law, especially all those that I cited, and please feel free to review and shepherdize all of it, there's not one thing that points to this being sanctionable conduct that warrants dismissal in this situation. In my opinion, it is a very black or white issue in this situation, especially given that we're in discovery and we provided it willfully, and we're trying to correct an error that unfortunately was made.
All right, Mr. Hoffman, last word.
Well, Your Honor, I'll go reverse order. As to Mr. Kratzer's assertion that, oh, well, we're still in discovery, no harm, no foul. We're in our, I think, third extension of discovery. As to Mr. Pomerantz's heart attack being a basis for him misremembering, our discovery requests were served on April 30th. And it appears to me, and I can't get in the mind of Mr. Kratzer or Mr. Pomerantz on this issue, but Mr. Pomerantz may have told Mr. Kratzer, yes, there's video. What I haven't seen today is any attempt by Mr. Kratzer to confirm or deny that statement by his client. Where's the email from Mr. Kratzer to Mr. Jackson saying, hey, my client says there's video. Is there video? We don't have any of that. The only evidence of mistake that's been presented to the court is evidence that has been created after the sanctionable conduct came to light. Now, Your Honor, as to willful misconduct, which is the standard for sanctionable conduct under 91137D, failure to cooperate with counsel about pending litigations that discovery can be made is willful misconduct. That's Phillips versus Peachtree Housing, 138 Georgia App 596. I don't know how this case got to this point under this set of facts other than Mr. Pomerantz lied. He either lied to Mr. Kratzer, he lied to me, he's made representations to the court that are false, and now that he's been caught with his hand in the cookie jar, he's trying to say, I made a mistake, let me try to fix it. If Mr. Jackson had not intervened in this case, or had not read the briefs, I would be forced to try this case without what I consider pivotal evidence. It is not up to the plaintiff. It is really not up to anybody but the jury as to what pivotal evidence is. The prejudice which would occur, is occurring, and can occur is when litigants hide evidence, they lie about its existence. And in this case, we have 3 separate instances where there were lies perpetrated. If you lie, you don't get to play because it hurts the other side in an unfair way. Sanction of dismissal is warranted in this case.
All right. Here's my ruling. I certainly think there is sanctionable conduct here. Parties have a duty of diligence and a duty of truth in discovery, and the opposing party is entitled to rely on a direct, straightforward answer and the truth to discovery. And what we've got, the pattern that emerges here is that there were contradictory discovery responses. First, there is video, and then there's not a video, which led, of course, defense counsel to say, we've got to get to the bottom of this, and we've got to figure out what the actual truth of the situation is. And I hear the excuses about medical issues and about inadvertence, but at the very least, it's negligence and it's carelessness about what's the truth, and that cannot go unremedied. However, I don't think that this conduct rises to the level of conduct that would support striking an answer. I think I can think of more egregious facts in this situation that would. If the plaintiff in this case had consistently denied the existence of video and it was discovered contrary to all prior denials, that would be that would be the type of concealment that would warrant sanction of dismissal.
Your Honor, the plaintiff did.
I'm still talking. If he withheld the video and never provided the counsel in the first place, that would warrant, that could certainly warrant dismissal. But he gave the video to counsel. The only way Mr. Jackson could ever have intervened and said, hey, I have the video, is because, at least at the outset, Mr. Pomerantz was truthful and candid with his attorney and gave him the information. So I don't see the level of willful disregard and the level of willful concealment in this case that would warrant the harshest possible sanction of completely destroying the case. Now, while that is correct, it is also correct that this careless behavior and perhaps even lack of full investigation of the truth does warrant a sanction. It caused Mr. Hoffman, on behalf of his client, to have to conduct follow-up discovery. It required a motion. It went through a response and it led to this hearing. And I think the appropriate sanction in this case is that plaintiff be awarded to pay all attorney's fees and costs from the time the initial false response was made until the present, all attorney work expended in pursuance of this issue. So, Mr. Hoffman, there's going to be a task for you, a follow-up task, to total that all up. And at least in the first instance, I'm going to ask And Mr. Kratzert has already said here on the record that he thinks attorney's fees are an appropriate sanction. So I'm going to ask, at least at the outset, that you confer with Mr. Kratzert and see if you can reach an agreement as to the amount of fees to be paid as a discovery sanction. If y'all cannot agree, then I will have a hearing on the total amount of fees and costs to be awarded as a sanction. And let me also address the issue of prejudice. I think certainly you've been prejudiced in the time that you've had to spend, and I'm trying to compensate for that prejudice. I think I see less prejudice at trial because you now have the ability to cross-examine the plaintiff on both the contents of the video and on his prior responses, and to attack the plaintiff's credibility and the plaintiff's memory. So I think at trial, all of that is right material for cross-examination on the issue of credibility, in addition to direct evidence of what happened at that time. So I don't believe there was such a prejudice that striking the complaint is the only possible remedy here. So that's my ruling.
And Your Honor, I just wanted to clarify, you had indicated attorney fees and costs in pursuit of this. You mean specifically the video issue? Is that my understanding?
Video issue,
Yes, sir.
from the time the false answer was given.
Yes, sir. Thank you.
So that'll be from the date of deposition or from the date of I just want to make sure that I'm clear, because I do have my homework cut out for me, so I don't want to be answering questions I don't need to. Will that be from the date of the deposition where he lied about the existence of the video through today?
Yes.
Okay.
Thank you, Judge. May I be excused?
You may be excused. Thank you, Mr. Jackson. That was very helpful. Thank you for appearing today.
Glad to help. Thank you, Judge.
Your Honor, I think that concludes my business as well with the court. If I can be excused, please.
You may be excused, and
Thank you, Your Honor. May I be excused as well?
you may be excused.
Thank you, Your Honor. Have a good day.
All right. We have all parties for DeBro Overstreet versus Limestone Partners.
Zach Wilson here on behalf of Limestone.
Arnold Rosanna here on behalf of the DeBro family.
Dorothy Paul here on behalf of North American Properties Atlanta and investors.
All right. So we've got a number of motions here, and I think the best way to handle this, given all of these motions, is to talk about the motion for summary judgment first. And I'm going to ask Limestone Partners Counsel to address his motion for summary judgment, but I want you to address it assuming, for purposes of this argument, that I allow the withdrawal of those specific admissions, and I allow potentially a substitution of party. Focus your arguments, if you can, on why you would be entitled to summary judgment regardless of those admissions being withdrawn and the incorrect party being named in the complaint.
Sure. Yeah, I can do that, Your Honor. May it please the court, my name is Zach Wilson, and I represent Limestone Partners, LLC. Basically, just a quick recitation of the facts here. The plaintiff alleges that on August 22nd, 2017, Ms. Overstreet slipped and fell in a parking deck of the Colony Square property in Midtown Atlanta. And then the lawsuit actually alleges a second slip and fall in the pretty much the exact same location on March 1st, 2019, about a year and a half later. And plaintiff brought suit against several entities, several linear parking entities. I'll just refer to them as linear parking. They managed the parking deck, and North American Properties was another defendant. They managed the property as a whole. And then they named my client Lionstone. And the plaintiffs alleged that Lionstone was the owner of the property, but has been made clear in the motion and supporting documents, Lionstone has nothing to do with this property, and the actual owner is an entity called LVA4 Atlanta Colony Square LP. This court may recall that the Lanier defendants actually filed summary judgment in this case back in December, based on several admissions that were made by plaintiffs as a result of their failure to respond to discovery. This court held a hearing on May 6th on that issue, and the court granted the Lanier defendants summary judgment by order dated June 28th, so just about a month and a half ago. Lionstone filed their own motion for summary judgment on May 12th on basically the same grounds as those established by Lanier, arguing that the admissions made by plaintiff through their failure to respond to discovery established the necessary elements for summary judgment. But Lionstone has the additional grounds that it is not and never was a proper party to the case, and that plaintiff's counsel was aware of this fact before Lionstone even filed their answer. Now, as set forth in the court's June 28th order granting summary judgment for Lanier, the plaintiffs failed to respond to discovery to requests for admissions that were properly served on them on June 2nd, 2020, over a year ago. OCGA 91136A2 establishes that a matter in a request for admission is deemed to be admitted unless a response is issued within 30 days. This court ruled in its order that the language of the statute clearly demonstrates that a party must strictly and literally comply with the terms of that statute. And the court cited G.H. Bass and Company versus Fulton City Board of Tax Assessors and Mays versus Ed Boyle's Chrysler Plymouth. The court affirmed in its order that the following facts, among others, were admitted and conclusive. The first, that plaintiff cannot identify the source of the substance that she's lived on. That plaintiff cannot identify how long the substance was present prior to her fall, and that the defendants were not aware of any hazardous condition at the time of the fall. And the court found that based on these admissions, the plaintiff failed as a matter of law to establish that the defendant had actual or constructive knowledge, and failed to establish that plaintiff was without knowledge of the hazard. The court also noted in its order that the Lanier defendants had presented an affidavit of an expert, Dr. Frank Manning, opining that to a reasonable degree of medical certainty, plaintiff's injuries were not causally related to the fall at issue. And that plaintiff admitted through her failure to respond to RFAs that she did not have any expert evidence otherwise. And this lack of causation evidence was an additional ground for summary judgment. The court likewise dismissed plaintiff's derivative claims of punitive damages, loss of consortiums, and claims for attorney's fees in its order. So, Your Honor, the basis for Lanier's dismissal in this case is equally applicable to my client, Lionstone. The facts and issues are the same now as when Lionstone filed its motion for judgment, and despite plaintiff's belated attempts at changing them, the facts still remain the same. So the plaintiffs did file along with their response to our summary judgment motion, a motion to withdraw their admission. And Your Honor asked that I address this summary judgment motion as if that motion was going to be granted. And even if that motion is granted, summary judgment is still proper with respect to Lionstone. So in plaintiff's motion, they only seek to withdraw 3 of the 11 admissions made in that discovery. And even if those 3 are withdrawn, the remaining 8 still establish the grounds for summary judgment for defendant. As you instructed, I'm not going to go into the other reasons why that motion should be denied, but assuming it's granted, the plaintiff still admits request number 1, which is that she does not know the source of the alleged hazard. She still admits request number 2, that she does not know how long the hazard had been there. Request number 8, that she traversed the same area prior to her fall. Request number 10, that she expected the presence of oil in the parking garage. And number 11, that she was actively aware of the presence of the oil prior in the area where she fell prior to her fall. These admissions, which plaintiff don't even attempt to withdraw, conclusively establish the elements of summary judgment on behalf of defendants of equal or superior knowledge of the plaintiff. The long and short of it, well, I'll again, assuming that is their motion to withdraw is granted, summary judgment still remains proper with respect to Lionstone. Now, with regard to the motion to substitute a party, again, taking your Honor's instruction that motion is granted. Although I do have to say, there's a statute of limitations issue in there, and OCG 91115C doesn't apply, but we can address that later. That still doesn't change the admissions that have been made already in this case, and that plaintiffs do not even seek to withdraw. The admissions about equal knowledge and about knowledge of the hazard, where it came from, how long it's been there, that sort of thing. So even if Your Honor was to dismiss Lionstone and insert the proper party, the facts remain the same, that summary judgment is still appropriate with regard to whoever that party is, because the plaintiffs still admit those key elements that are necessary for summary judgment. Again, our position is that it's too little too late to substitute a party, and that plaintiffs were aware of this of the proper party for almost 2 years. But I can address that if Your Honor needs me to further down the line. But Your Honor, that's the long and short of it. It's the same basis as Lanier defendants. Nothing has effectively changed. All the effective requests for admissions that were admitted by their non-response are still applicable to this case currently. So that's where I'll leave it for now, unless Your Honor has any other questions.
What is the effect of not withdrawing admissions as to equal knowledge or superior knowledge, but plaintiffs claim that, well, there's other evidence in the record that suggests that they did have superior knowledge because there was someone, there was an employee or someone else in the area that could have seen it. How do you respond to that?
Well, first, Georgia law is clear that it's based on equal knowledge. So the fact that plaintiff has admitted that she was she was aware of the presence of oil in the area, you can't have more knowledge than that. Even if this person who, again, there's a question as to who he was, who he's employed by, all that stuff. Even if he said, yeah, I knew there was oil there too. They both knew there was oil there. By that admission, Georgia law says equal knowledge, summary judgment for defendant.
All right. Mr. Lozana. So Mr. Lozana.
Yes, Your Honor.
I understand we've got your motion to substitute parties and your motion to withdraw certain admissions. The trouble I'm having is that even with the admissions you requested be withdrawn, based on the other admissions and the other facts and circumstances in the record, I'm not seeing a question of fact. So you've got to help me with that.
Right, Your Honor. So there are a number of questions of fact that would make this case inappropriate for summary judgment. And the other requests that Mr. Wilson mentioned, he says that we did not address, were in fact addressed in our brief, and mostly relate to the defendant's mischaracterization of what the standards are for a premise liability case in Georgia.
No, see, the problem is though, that the matters that were deemed admitted in the request for admissions are deemed conclusively established as matters of fact. So giving me contrary facts in a brief doesn't create a conflict in the evidence if the matter is already conclusively established by the admission.
Sure, that assumes that it is conclusive, and we dispute that, Your Honor.
It seemed that way. So tell me, if the admission is, I knew about and perceived the oil in that exact same spot prior to my fall, tell me why that doesn't conclusively establish that she had equal knowledge, at the very least.
If that was in fact the admission, then we would have a problem, Your Honor. She did not, that was not the admission. Even if you take into account the other items that Mr. Wilson said we didn't address. At best, giving Mr. Wilson the benefit of the doubt of his review of the evidence, Ms. Dubrow acknowledged during her deposition that it would not be unusual to expect that there would be some oil in the garage. She didn't say that she knew of a particular hazard that she slipped on and before she slipped on it.
Right, you're referring to her deposition. The problem is we have admissions that are conclusively established for purposes of this action relating to what her perception was of the oil in the parking lot. So that matters established for purposes of summary judgment.
So, Your Honor, even if that were true, because you said omissions of fact, right? We're talking about factual matters. A plaintiff doesn't have to show that she knew of the oil in order to show constructive knowledge that the defendant had about the oil and the hazard. So that's part of the misdirection in this case. All the focus is on whether Ms. Dubrow knew about this particular hazard before she slipped, as if that is a conclusive or sort of the definite nail of her claim here. She doesn't have to show it. Knowledge can be established in a premise liability case constructively. And we think that the evidence that there was an individual in the area where she fell who could have also seen the hazard is sufficient to establish a constructive knowledge of the hazard. If the request for admissions were attempting to get an admission on a legal issue, that would be an improper request for admission anyway, because the discovery is designed to discover facts. So the way that these admissions were drafted were also very unclear to the point where even a factual response would be virtually impossible to give one that is meaningful. For example, then shared with you that there were 2 falls in this case. The admissions at issue don't even distinguish which fall they're referring to, which puts the responder in an impossible position. How can you claim that there are facts established conclusively when the question wasn't even clear enough to determine which fall you're talking about? So there's a problem with that as well. So, Your Honor, I think that the facts in this case, there are many facts in this case that are in dispute. The big one is the defense agent who was in the area may or may not have seen the hazard prior to the fall. That's still a fact question that needs to be resolved in this case. Whether defendant had any protocols in place to even discover whether there was a hazard is still a fact question in this case. Even if they did have protocols, were those protocols followed? if they conducted an inspection prior to the fall, was it properly conducted? The admissions also that Limestone is alleging here would only be effective to the Lanier defendants, who were the only ones who posed requests for admissions from the defendants. And it would be reasonable to expect that any responses that would be binding on plaintiffs would be responsives to the Lanier defendants. So asking a plaintiff if defendant was aware of a certain hazardous condition, we would have to assume that the defendant that we were talking about is Lanier. They're no longer in this case. The Limestone and North American defendants never served any requests for admissions. It would be inappropriate for the court to assign them the benefit of any responses to requests for admissions that were in response to another defendant who's no longer in the case. So, Your Honor, these are really the highlights of our opposition to the motion for summary judgment as being really inappropriate in this case.
All right, Mr. Wilson, give you the last word on summary judgment.
Sure, and just to address some of those points, Attorney Lozana talked about constructive knowledge. Again, like we discussed, even if Lionstone had actual knowledge, the RFAs have established conclusively that the plaintiff also had actual knowledge, and so summary judgment is still appropriate. Of course, we don't believe there is any evidence of actual or constructive knowledge in the case. And he also talked about the request, the responses only being applicable to the party that served them. And that, Your Honor, it's my understanding that's just not true. It's if a party served discovery responses in a case, those responses are deemed to be true and accurate no matter which party relies on them. And so, he talked about the fact that no hazardous condition which was known to defendants. That's request for admit number 9. And Your Honor, I was assuming that you had granted their motion to withdraw number 9. Even if you did that, plaintiff still admits that she knew that there was a hazard there before, that she expected the presence of oil there, that she didn't know how long it was there or where it came from, all that sort of thing. That's grounds for summary judgment in any case. So that's really all that I have to respond to that, Your Honor.
All right.
Your Honor, if I may, I'm Dorothy Palm here on behalf of North American Properties. I filed a notice of joinder last night to adopt and join in co-defendants' motion for summary judgment. It's our position that as we are the property manager for the property, the same arguments raised by a co-defendant would apply to us as well.
So you've just joined in the motion as of what date?
Yesterday.
All right. So obviously I can't address your motion if you're just making it. Because I'd have to give Mr. Lozana an opportunity to give any additional response he'd want to give to that one. He's entitled to that extra period of time. So we'll have to defer on that one.
Okay, Your Honor.
So, you may be able to telegraph what the ultimate result will be based on my ruling here today. My ruling as the Limestone Partners motion, the motion for summary judgment is granted. It's granted based on the admissions that were that are deemed admitted and not requested to be withdrawn. Those admissions established that the plaintiff in this case at least had equal knowledge of the condition in the parking lot and the hazard, and that applies to both falls because according to the complaint, the falls occurred in the same location. Both falls occurred in the same location. I'm assuming for purposes of this motion, that even if Limestone Partners LLC was the correct, whether it was Limestone Partners LLC or LVA4 that was the correct party in interest, either party would be entitled to summary judgment for the reasons I've given. And even if I had granted the motion to withdraw admissions, specifically the 3 admissions that were requested to be withdrawn, the remaining admissions establish that the plaintiff cannot maintain a claim that survives summary judgment in this case. Mr. Wilson, if you would submit a proposed order, copy the other parties on it, and then submit it to Mr. Townsend. If Mr. Lozana will agree, at least as to the form of the judgment for purposes of establishing the record for appeal, that would be helpful, but otherwise I will take any proposed modification that the other side has on that.
I will do that, Your Honor. Thank you.
All right. There's no further business on this case. Everybody may be excused.
Thank you, Your Honor. Have a good day.
Thank you.